Next, let us look into the next aspect, stopping of proceedings under section 258. It is in the interest of justice to put an end to the litigation, so the CRPC provides power to stop the proceedings when it is not in the interest of justice to carry out the proceedings. It states that in any summons case instituted otherwise than upon a complaint, magistrate of first class or with the previous sanction of Chief Justice Magistrate or any other judicial magistrate may, for reasons to be recorded by himself, stop the proceeding at any stage without pronouncing any judgment. After going through the CRPC, let us look into the next area, the Hindu Marriage Act 1955. Marriage is one of the most important institutions and which links between wife and husband. We cannot accept the growth of man and his development in isolation. Man by nature is a social animal. The relationship between husband and wife is based upon mutual trust and uncontrolled love between them. If there is any dispute between the spouses, then it can be dissolved in a better way by restoring the lost trust with the help of mediation and conciliation. Going to the court to resolve the dispute, it may cause more damage to the relation between husband and wife. Section 23 of Hindu Marriage Act provides a separate provision in order to reconcile and settle the disputes amicably. This section provides that before proceeding to grant any relief under this act, it shall be the duty of the court in the first instance, in any case where it is possible, so to do consistently with the nature and circumstance of the case, to make every endeavor to bring about reconciliation between the parties. For the purpose of aiding the court in bringing about such reconciliation, the court may, if the parties so desire, or if the court thinks it just and proper to do so, adjourn the proceedings for a reasonable period not exceeding 15 days. And they refer the matter to any person named by the parties in this behalf or to any person nominated by the court if the parties fail to name any person, with the directions to report to the court as to whether reconciliation can be and has been effected, and the court shall, in disposing of the proceedings, have due regard to this report. After going through the Hindu Marriage Act, now let us look into the last area, Arbitration and Conciliation Act 1996. The object of the act is to provide speedy disposal of cases with less expenditure. This act reduces the workload of the court, which is growing threat to the administration of justice in our country today. Main features of the act are as under. This act sought to ensure the minimum interference of the court in arbitration process, and alternative dispute resolution can be used at any time, even when the case is pending before the court of law. Alternative dispute resolution can be terminated at any stage by any dispute to the parties. This act permits the parties to choose neutrals who are specialists in the subject matter of disputes. Arbitral award under section 36 of the act has been given the status of decree of the court. Section 71 of the act makes the settlement agreement reached with the help of the parties enforceable as a decree of the court. As far as the rule of procedure is concerned, the proceedings must have been conducted in the appropriate manner and principles of equity has to be followed. A new approach in administration of justice providing alternative like mediation, conciliation and lok adalats. Arbitration is the source of other alternative not only in the substance but also in the procedural working of alternative methods of dispute resolution. In addition to arbitration, this act has also recognized conciliation as a means of settlement of commercial disputes. So any commercial dispute you can bring under this act and settle by means of conciliation. Conciliation is a procedure in which a neutral individual is appointed in order to assist the parties in reaching a mutually satisfactory resolution of disputes. It is usually used as an appropriate method in resolving family disputes. So, Arbitration and Conciliation Act 1996 plays an important role in settlement of the dispute in a speedy manner, and it recognizes the dispute settlement in a speedy and fast manner. After going through various provisions recognized under the Indian laws like Constitution, Code of Criminal Procedure Code, Hindu Marriage Act, Arbitration and Conciliation Act, now let us conclude this session by making certain statements. Though there are a number of enactments for legal aid and speedy disposal of cases as discussed above, which could not provide the desired result to the public in providing speedy justice and amicable settlement. Need was felt for a new enactment and enforcement of separate laws to deal with legal aid and speedy disposal of cases. Keeping in mind this objective to cater to the needs of the society, the Indian Parliament made a separate law, that is the Legal Services Authority Act 1987, and this enactment came into force in the year 1995. So with this, I am trying to conclude the session, and I wish you all the best for your exams. If you are having any dispute, if you are having any discussions, any problems with respect to the topic we discuss, you can contact or you can email to the forum. I will be available to you and I can give my advice, I can give the solution, and I will give the ideas with respect to the topic which we discuss. Thank you.